Hello, and welcome to episode 55 of Stand Up. Joining me today is Professor Eric Segall, constitutional law professor of Georgia State University, and I know there is so much talk about the election. There is so much talk about the coronavirus, but this Wednesday, the Supreme Court is going to be hearing arguments on a very important case that will determine the future of women's reproductive rights in the United States. Joining me to talk about it today, back again, one of your all-time favorites, the legal eagle, Eric Segall. Hello, everybody, and welcome to Stand Up, episode 55, where every episode, basically like a classroom, I invite the smartest people I can find that I have access to. I usually give them a call. Sometimes I meet up with them, throw a microphone in their face, and we talk about all the important issues that matter to you, your family, your community, your planet, your soul. We fight depression and anxiety, existential fears about anything from climate change to just good old mortality, I mean. Joining me today, Eric Segall. Everybody loves him. Talk about the Supreme Court and the big case on Wednesday. Before we get to it, let's listen to a little bit of my stand-up from over the weekend. Everybody is terrified and concerned with coronavirus, COVID-19. We've been talking about it a lot here with Dr. Megan May, who is an expert on epidemics or pandemics, an immunologist. But I had some jokes over the weekend performing at the comic strip and Dangerfields in New York City. Take a little listen before we get to Eric Segall to some of that. All right? I don't know what's going to happen. I just know I don't want to get this virus, you know? I've always made fun of germaphobes, and now I'm like, everybody, let's wash our hands for 20 seconds. The craziest thing is that it really wouldn't be as big of a deal if you had better leadership, and any of the countries where it started in China for sure, but certainly here in the US too. Like Trump is the president, he's a game show host, and now he's in charge of controlling a pandemic. Do you feel safe yet? He just appointed Mike Pence. Mike Pence, who thinks the moon is made of cheese and the earth is flat, is going to stop the pandemic. Mike Pence is... Yeah, he said smoking at one point. He wrote a column that tobacco doesn't cause cancer. Yeah, he was probably paid by the tobacco lobby. Mike Pence is a fucking monster. The way he just looks at Trump is like, And Trump, hates the guy. He can't stand being around Mike Pence. Like, listen, you're just there for votes from the Christian crazies, okay? All right. Okay. Why does Trump always do this? Like he's got an accordion, but he doesn't. It's like, you know what, listen, we've got the coronavirus. This is how shitty of a leader he is to control a pandemic. It doesn't matter where he's at. Even if you support Trump, you have to admit that this makes you feel a little uneasy. When he tweets about the virus and gets the spelling wrong, it makes me think he doesn't know how to stop it. He spelled it Corona. I feel bad for Corona beer right now. I hear their sales are. But there's a bar in Aspen, Colorado called ISIS, and it survived. So listen, really, yeah, it made it through that whole shit show.
I keep seeing people wearing masks. I want to punch them right in the face. Masked people. The masks are not for you. The masks are for healthcare workers. That's who they're for. That's what I was told. My wife ordered masks. Amazon said they're going to arrive in May. For real. I want to walk up to a person I see with a mask on and just like lick. Gotta lick them right on the face. Just watch them flip out. Just cough, and then as soon as they see you cough, like,
All right, performing a little bit over the weekend, fun little audiences. And now let's get to my guest today. It's Eric Segall of Georgia State University. You got to get his books, Supreme Myths. The court is not a court. Justices are not judges, and of course, Originalism as Faith. Follow him on Twitter at @eSpinSegall. I left the opening when I called him on this interview because it was just funny. Us trying to figure out how to connect and listening to him struggle and test the whole line. And then we get right into what was like an almost hour-long conversation. I hope that you appreciate it. I know there's a lot going on with the election and with the pandemic, and there's a lot of media out there for that. But this Wednesday, big case, Supreme Court. Here it is, me and Segall.
Hello.
Segall.
Hello. Dominic.
Are you ready to rock?
You want me on speaker or you want me not on
Let me
speaker?
hear what speaker sounds like.
This is speaker. I am talking to you on speaker right now.
Oh, take it off.
Hold on. What? I don't understand.
Count to 10 and then press off.
1, 2.
Don't count to 10 like you're mad at me. Just count to 10.
1, 2, 3, 4.
All right, now take it off speaker.
It is off speaker. I'm off speaker right now.
Okay.
This sounds okay?
Sounds great.
Okay. Then we're ready to go.
Let's talk about the Supreme Court case that could dismantle Roe v. Wade. Eric Segall, it's called June Medical Services v. G, and it could pave the way for individual states, to restrict abortion access out of existence. And many states already have very tough restrictions, very hard to get an abortion. Let's talk June Medical Service versus G, Segall.
Okay, Pete, thanks for having me on. This is one of the more unusual cases you and I have ever talked about in our 10-year career together. The reason it's an unusual case is because the law that I'm going to describe in a minute was struck down by the Supreme Court just a few years ago. In that case, the law was a Texas law. In this case, it is a Louisiana law, but it is exactly the same law. What many states have tried to do is enact statutes that require doctors who perform abortions to have medical privileges or visiting privileges at a hospital within 30 miles of wherever it is they perform their abortions. The reason this is a big problem is that in the red states, and they're almost all red states, that have those laws, hospitals generally do not give admitting privileges to doctors who perform abortions.
Let's step back for a second, though, because the easier way to explain this is there was a law that was struck down in Texas. Now this is a law out of Louisiana. You say they're the same law. Explain how the anti-abortion, or as they like to refer to themselves, the pro-life movement, lobbies to get these laws written so that they will create an atmosphere and a regulatory structure that will make it more difficult for there to be abortions, including laws they write that say the hallways have to be a certain width. These are all loopholes they exploit to make it more difficult for women to have their pregnancies terminated, right? That's the whole game.
Yes, the anti-choice movement, as I refer to it, because it's not, I don't believe it is a pro-life movement for all of the cliched reasons, but accurate reasons we talk about. They don't really care about the fetus after the fetus is born. So it's not really a pro-life movement. It is an anti-choice movement, wanting to take the choice away from women to have abortions. As the law currently stands.
And away from doctors from performing them.
Say that one more time.
And looking at it conversely, I think it's important. It makes it harder for women to have abortions, but it also makes it harder for physicians to provide abortions.
Yes, and for clinics to stay in business to provide abortion services.
Yeah.
There are three ways: make it harder for the woman, make it harder for the doctor, make it harder for the clinics themselves. Those are the three.
So these laws are written. So go ahead.
And I want to be clear about something that a lot of even legal scholars sometimes are lazy about. We're not talking about Roe versus Wade. We are talking about a case called Planned Parenthood versus Casey, which is the case from 1992 that changed dramatically what the law of abortion was. Before that 1992 case, states could do almost nothing regulating abortion until after viability. Women had a fundamental right to terminate their pregnancies before viability. After Planned Parenthood versus Casey,
viability is just when the baby would live on its own if they were, what is that?
Viability is when the fetus could live outside the woman's, outside the womb.
Okay,
yes.
Sorry.
Obviously, a one-day-old baby needs human beings to take care of them. But the idea is the idea is a viable fetus, and humans are the equivalent. That's the idea, whatever that's worth. And what Planned Parenthood versus Casey changed was, instead of calling this a fundamental right for women to terminate their pregnancies, states could now pass laws affecting and restricting a woman's choice to have an abortion as long as they did not place an undue burden in the path of women seeking abortions. And they defined undue burden as a substantial obstacle. However, as Justice Scalia correctly, and that's a sentence I hate to utter, but as Justice Scalia correctly pointed out in his dissent in that case, at least Roe versus Wade was clear. All of the restrictions that people know about, waiting periods and absurd informed consent requirements that states require women to go through, and now admitting privileges laws, all of that was unconstitutional before the Casey case. After the Casey case, those laws came into play. But what is an undue burden, what is a substantial obstacle, is incredibly ambiguous. And as Justice Scalia said, if a judge is pro-choice, he is likely to find such laws to be an undue burden. If a judge is not pro-choice, he or she is less likely to find the law an undue burden. And that's exactly what's happened. So there is an organized movement that goes to state legislatures and gives them, uniformly written ideas and laws about how to restrict or make it more difficult for women to get abortions. And one of the ways that happened in, I think, over 20 red states was this idea that for a doctor to perform an abortion, he or she has to have admitting privileges in a hospital within 30 miles of that clinic or the doctor's office. Now, because Texas had this law and many other states had this law, this issue was litigated all over the country. And virtually every court that looked at it said there is no benefit, none, to women's health to this law, but there is substantial burden on doctors and clinics and women because of this law. And eventually, that's what the Supreme Court held in a 5-3 opinion. This was when Scalia had died and before the election in 2016. Right. And my friend, retired Judge Richard Posner of the Seventh Circuit, wrote an opinion that the Supreme Court actually borrowed from when it decided the case, with all kinds of statistics, all kinds of data about how this medical admitting privileges law did nothing for women's health. Now, in Texas, it was very clear that this law would require many, many clinics not to be open and many doctors not to be able to perform.
Yeah, it would prevent what was the effect of that? Basically, when they passed it in Texas, it was going to make it much harder for abortion clinics to operate, for physicians to go to those abortion clinics, for these ridiculous hurdles and obstacles that they created, which, by the way, I think is most important to mention. The medical community, physicians, OB-GYNs, the experts on this, they never thought these regulations were required. These were legislators, politicians, anti-choice politicians, just creating laws that the medical community didn't see, is my understanding. Are you sure?
Yes, that's exactly right, Pete. Exactly. And in fact, in Texas, there was a legislator, I'm paraphrasing this, but there was a legislator who basically said, what we care about is reducing the number of abortions, not making them safer.
Oh, he admitted it.
Pretty much, yeah. And that is, we can all have opinions, and Pete, I am sympathetic to people who think the fetus is a human being upon fertilization and that we shouldn't be killing them. And I'm
sympathetic to people who think that vaccines are going to harm their kids. They believe, for whatever reason, they believe it.
No, that's different.
You don't have sympathy for people. I thought we were agreeing that you have sympathy for people who believe what they believe for what I think are the ridiculously wrong reasons.
When life begins is a moral, philosophical question. Whether vaccines cause autism is a scientific question. And my understanding, because I have a good friend involved with vaccines, there is no medical evidence suggesting vaccines cause autism. None. Zero. But when life begins is a moral, philosophical, legal question that people can differ about. It's
Fair enough. All right, you changed my mind. Based on, listen, it's bioethics with Segall. All right, so where did I get off track there?
Okay, so let's go back.
Yeah.
So the Supreme Court strikes down this Texas law 5-3. And by the way, Justice Kennedy, between Casey in 1992 and this case in 2016 out of Texas, Justice Kennedy, who was the swing vote, of course, in all these 5-4 cases, showed that a lot of sympathy, or people were worried he was going to switch sides and maybe even go to the point of overturning the Casey decision, which he helped to write. The fact that he joined the 5-3 decision overturning the Texas law was a very big deal. And we kind of thought at that point, this is done. That decision written by Justice Breyer was painstaking. Everybody who knows anything about the Supreme Court knows that Justice Breyer is both incredibly boring and incredibly painstaking. And he wrote a long, boring, but scientifically accurate and factually correct decision that demonstrated beyond a shadow of a doubt to any reasonable person that the Texas law had no medical benefits, but made it much, much harder for women to get abortions. After that case came down, Louisiana had passed its law before that. After that case came down, there was a kind of a stalling period, but then Trump got elected.
Right.
Then Justice Gorsuch got on the court, and then Justice Kavanaugh got on the court, and the law in Louisiana, which was the exact same law, the Louisiana started saying we're going to enforce that law. So, of course, family planning clinics and doctors challenged it. In the district court, the lower trial
these laws, basically what happens real quick is that if one court with a certain makeup of judges rules one way, you wait until there are new judges on that court and you bring a similar case to get a different ruling. That's how this works.
Well,
it's not a conservative liberal idea. That's how it always works in the courts in America.
I wouldn't quite put it that way. In this case, Louisiana decided that it was going to try to enforce this law, even though not lawyers and litigators. Louisiana decided it was going to try to enforce this law, even though the Supreme Court had struck down the identical law. This is an important procedural point, Pete. That's really important for your audience to understand, because when this case is being argued next Wednesday, and there's going to be a lot of press about it. So once Louisiana said we're going to enforce this law, almost immediately, of course, doctors and clinics went to court to seek an emergency injunction, getting the law stayed, because it was the same law the Supreme Court had just struck down. They filed an emergency petition for a stay, which went through the lower courts, and then the Supreme Court of the United States granted the stay. What that means is that law couldn't go into effect until it was approved by the Supreme Court at some point. And Justice Roberts joined the four liberals in granting that stay, even though he was in dissent in the Texas case. Let me unpack that one more time.
Yeah, I don't know.
So the Texas case is 5-3, okay? And Roberts dissents and says that law is constitutional, the admitting privileges law. There was another law at issue too, but let's not worry about it. The admitting privileges law the majority held it's unconstitutional, strikes it down. Justice Roberts says, no, I dissent. I think we should uphold this law. Then, roughly a year and a half or so later, a year later, the exact same law Louisiana tries to put into effect. What Justice Roberts was doing when he granted the stay was saying to the world, you can't approve a law that we just struck down. We, the Supreme Court, just struck down. Otherwise, you're basically disobeying the Supreme Court.
It's backwards. Yeah.
Yeah. But remember, Roberts already said that law was constitutional. So what he was doing is just making a point about Supreme Court power. Even though this is Justice Roberts in very lay terms. He didn't say this. I'm just saying this is the import. Even though I voted to rule that law valid, even though that was my vote in that case, when another state passes the exact same law, you can't do that until I tell you can, until the court says you can do that again, which makes sense, right? I mean, if the Supreme Court strikes down law A on June 1st and a different state passes the exact same law on June 10th, the Supreme Court's going to stop it.
Yeah.
Because that's okay. That all makes sense.
Yeah.
So, right. So the district court gets the case and says two things. Says, of course, I'm bound by Supreme Court precedent, so this law is valid. But he went much further and wrote a very, very long, detailed opinion as to why the Louisiana law was exactly the same as the Texas law with the same effects, meaning no health benefits for the woman, undue burden on women seeking abortions. Then the case got appealed to the hellish Fifth Circuit Court of Appeals, the most conservative court in the country, I think, or at least one of them, and a 3-judge panel, despite having a law that was identical to the one the Supreme Court struck down just a couple years earlier. They said the law was constitutional because Louisiana is different than Texas. And they gave some ridiculous and bogus reasons for that, which will bore your audience.
Would it really bore the audience? The Fifth Circuit, by the way, is Texas, Georgia, and Louisiana. Is that it?
Texas, Louisiana, and Mississippi. Yes. And what the Fifth Circuit said in effect was the evidence in Texas that many clinics would close and that doctors would not be granted admitting privileges. Those facts don't apply to Louisiana, and we think both of those things aren't true in Louisiana.
What is the legal argument to create these onerous regulations that the anti-abortion movement makes? What is the legal argument that a judge
there's only one.
Should even hear what?
There's only one.
Go ahead.
If you're regulating the procedure itself, you have to do so for the health of the woman. And that's what Louisiana is arguing.
But how can they argue that if there are no medical experts that agree with them?
Well,
the judges just disregard the medical community.
Yes.
Like they live.
Yes.
So a court can decide a case on any issue without there being expertise on the issue, scientific. I mean, isn't that?
Yes.
Give me. Are there many examples?
Yes, I could give you.
Yeah, well, is there a liberal one so we can shit on liberals?
My book, Supreme Myths, details many of these. Well, of course, Roe versus Wade.
Let me go find Supreme Myths. I'm in my home studio. I think it's lying around here. It's right. It must be right near your other book, Originalism as Faith, which is your new book. But let me find it. So, what is it in Supreme Myths that you say?
Well, no, let me give you a better example that your audience would be more interested in that I actually did not discuss in Supreme Myths, and that is campaign finance reform, for example. Not virtually, but most experts on election law will tell you that when super PACs and other groups make expenditures on behalf of candidates, they do so in secret coordination with those candidates. That's illegal. But the Supreme Court has turned a blind eye to that, in effect. There's a lot of data supporting it, and the Supreme Court has turned a blind eye to that.
Why is that a great example of... I mean, that's subjective. There's some subjectiveness to that. There's some bearing of proof that they're in coordination, the super PACs in coordination.
Louisiana is saying there's some subjectiveness about whether this law is really for women's health.
Well, if you just ask experts on women's health, and if they uniformly or unanimously say yes or no, then the judges are obligated to go with the best science, especially if there is a consensus. If there is a huge controversy or disagreement about what the best course of action medical treatment is, then I can understand, judges maybe having some responsibility. But otherwise, why would a judge have any responsibility or authority or power over, say, the entire medical consensus, scientific consensus, OBGYNs?
Let me repeat something that I have said to you many times, both publicly and privately. In important constitutional law cases like abortion, freedom of speech, affirmative action, those kinds of cases, the Supreme Court of the United States and appellate courts where there is not a binding Supreme Court decision, ironically here there was, but leaving that aside, they don't decide cases based on law and facts and precedent and history. They decide cases based on their value judgments.
I understand a value judgment when it comes to things that are dealing with sociology or history or injustice or inequality as anybody might perceive it, such as affirmative action. I understand there being a conversation about that. I don't understand there being a value judgment about something, a medical procedure, one medical procedure, where the vast majority of the research, the science, and the experts all agree on how that medical procedure is most safely done.
Well, let's back up a second.
Where does the court have anything to say about that? That's not subjective.
If you said this to a anti-choice constitutional law professor, the first thing that anti-choice constitutional law professor would say to you is something that I, in fact, have said to you, which is both Roe versus Wade and then Planned Parenthood versus Casey, which changed it but still kept the right, is all made up to begin with. So why can't they make up other stuff? It's all made up. In fact, Pete, I have a blog post coming out on Monday on Dorf on Law based on a conversation I had with an NYU, which is a top 5 or 6 law school, law professor whose expertise, this is relevant, whose expertise is actually like intellectual property and copyright, but he knows a lot about constitutional law. And he began teaching constitutional law to his NYU students who are very, 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 very smart. He stopped teaching constitutional law. And a couple of days ago, he tweeted, this is his tweet. This is not Segall. This is a guy named Christopher Sprigman at NYU Law School. I decided I couldn't teach constitutional law anymore because when my students realized that it's all just made up by the Supreme Court, they were very disappointed and they wanted to believe there's a discipline here and there isn't. And I can't handle that frustration.
You've always said the Supreme Court is not a court. You even carve that in the sand on your recent vacation. Yes. That's how much you care about it. Okay. Yes. And by the way, I'm going to post this on Wednesday. So that post that you mentioned will be up. Yes. So I'll link to it, everybody. It should be. I'm looking into the future. If we're both still alive, that post will be linked.
So what the Fifth Circuit said is it made up a bunch of stuff about the facts that wasn't true. Then
about the facts of the medical procedure and the safety of it.
About the alleged differences. But no. Texas made up a bunch of facts about that, which Justice Breyer debunked 100% in his decision in 2016.
I want to read that now.
What Whole Women's Health versus Hellerstedt. What Louisiana had to argue, Pete, was our case is different than Texas's case because the law was identical. So they had to say something as to why their case. Now the reality is what's different is Justice Kennedy is no longer on the court and Justice Kavanaugh is. That's the real difference. But of course you can't say that. So what they said was in Texas, they proved that doctors could not get admitting privileges at hospitals in certain areas. And they proved that many clinics would close. The plaintiffs in this case did not prove that, so we should win. Now, again, the district court, the trial court, made all kinds of factual findings. Pages and pages and pages and pages and pages from doctors, from experts who said this law has no medical benefit and places a substantial obstacle in the path of women seeking abortions.
So this is being argued today in the Supreme Court, if this posts on Wednesday, let's say. And how will this, how do you predict, this is the game that you have to always engage in, the arguments, or if we have time.
Well, one more thing. Sorry, Pete. One more thing. There's one more issue in this case that sounds hyper-technical, but it's being argued. Generally, so we have a legal doctrine that's called mootness. If I file a lawsuit and against a defendant, and I eventually get everything I want from that defendant before the case is over, then my case is moot, obviously. And I also have to be personally injured to bring a case in federal court. I have to have an injury of some kind to bring a case. And the Supreme Court has decided, 30 abortion cases, whatever it's been over the last 5 decades. The woman who originally files the lawsuit, of course, is no longer pregnant when the case gets to the Supreme Court because it takes more than 9 months for that to occur.
Oh, wow.
Right? So normally the people bringing these lawsuits are doctors and clinics, both on their own behalf and on behalf of women. Now, I know this is getting complicated, but people are not normally allowed to assert the rights of third parties. So, for example, there's a famous case out of Colorado where somebody was sentenced to death and his mother filed suit, and the Supreme Court, but the guy didn't. He wanted to die. And the Supreme Court said the mother can't assert the son's rights. However, ever since Roe versus Wade, the Supreme Court has said on at least 20 occasions that both doctors and clinics can bring lawsuits on behalf of women asserting the rights of the women because they have a close relationship to those women. And in the case of clinics, they have a financial relationship, as do the doctors, and so on. That's been a given forever, Pete. That's just been a given. Louisiana is arguing that the doctors and clinics in this case don't have standing, that terrible word, to bring this case. And the Supreme Court said it wanted briefs on that issue. That's very strange. That's very, very, very strange. I just want to alert the audience to that issue. Justice Thomas, in dissent in the Texas case, raised that issue. I don't think the court is going to go there, but it very well might, which means it would throw the case out it would throw the challenge out. The Louisiana law would stay in effect until a woman challenged it, into a woman seeking an abortion. I know that sounds hyper-technical.
The Supreme Court, when they'll hear argument Wednesday, and
yes.
you're saying you predict they'll throw it out until.
No, I'm not predicting it. I'm not predicting. I'm saying they asked the parties. Oh. This is the fact, to brief the issue. Should the doctor and the clinic have standing to bring this case, which has been clear since 1973. And so why is the Supreme Court asking for briefs on that issue is a question that has a lot of smart people very, very confused. But I just want to raise that to give a complete story of the case.
All right. So now, getting to the case.
But let's go back to the merits. Let's go back to this admitting privileges law.
Admitting privileges for physicians at abortion clinics.
They have to have admitting privileges at a hospital 30 miles away, but within 30 miles. But in Louisiana, of course, most hospitals don't grant those privileges. So it's in effect preventing doctors from performing abortions. I think the data is if the law is passed, only one doctor in Louisiana currently will be able to perform abortions or something horrific like that. There's only one clinic, I think, in Louisiana, or there'll only be one clinic if this law is passed.
Yeah, as of 2017, 89% of counties had no abortion clinics.
Yes.
6 states had just one clinic.
Yes.
Yeah.
So why would the let's go back to campaign finance reform for a minute, okay? Because it's directly relevant.
It's so boring.
After Citizens United, Montana decided to enforce a campaign finance law that was exactly, or for all legal purposes, the same as the law the court struck down in Citizens United.
Yeah, because of Montana's rich history of anti-corruption and understanding the issue of money in campaigns, which is what Citizens United allowed for when it decided that corporations were people and speeches. So on
and so forth. Doesn't matter. So on and so forth. Montana said what happens in our state is unique and different than what was at issue in Citizens United. The Supreme Court used a procedural device called a summary reversal, where the court wrote 2 paragraphs, basically, and said, this law is unconstitutional. It is the same, I'm paraphrasing, it is the same law that we struck down in Citizens United, and we don't have no arguments, no briefs, we're just striking it down. The Texas law and the Louisiana law are the same. So when the Fifth Circuit upheld that law, the Supreme Court should have just summarily reversed it and said, we struck down this law 2 years ago. Why? It's gone. But they didn't do that. Why would the court take this case if it's not going to affirm the Louisiana law and either say it's different than the Texas law, which is really, really, really stupid, wrong, and not justified by the facts, or just reverse the Texas case altogether? This is what if you asked 100 constitutional law professors the question, what's going to happen to Roe versus Wade and, more importantly, Planned Parenthood versus Casey, I suspect 70 or 80 would give you the same answer. The court is going to weaken it, and then weaken it some more, and then overturn it altogether. That's what's going to happen. By the way, one more thing. Justice Roberts is the key. We already know how the 4 Fox News justices are going to vote, and we know how the 4 liberals are going to vote. It comes down to Justice Roberts. And here's the thing, Pete. Justice Roberts' wife works for, and may even have been the head of at some point, an organization called Feminists for Life. Not Feminists for Life. Feminists for Life.
It's an anti-abortion women's group?
Anti-choice women's
Justice,
group. Yes.
So meaning trying to read into what the guy's going to decide based on what's best for his marriage.
No, I'm not saying that. No, well, yeah, I'm not saying that. I'm just saying, all I'm saying is his wife is wildly anti-choice.
Yeah, I'm looking
Justice
it up right
Roberts
now.
has voted to strike down, with the exception of that one procedural wrinkle I told you about. In every case that has made it to the Supreme Court on the merits, Justice Roberts has voted to uphold to uphold anti-choice laws.
When he was asked by Senator Specter in his confirmation hearings about Roe v. Wade and whether or not it was settled law, Roberts said it's settled as precedent of the court, entitled to respect under principles of stare decisis. Is that how it's pronounced? And those principles applied in the Casey case explain when cases should be revisited and when they should not. And it is settled as a precedent of the court, yes.
Doesn't mean anything.
Okay.
And
his wife is strongly pro-life. I'm looking at this.
Let me be nonpartisan.
OnTheIssues.org, everybody. Yeah.
Let me be nonpartisan about this so people understand where I'm coming from. A few months before Sonia Sotomayor had her confirmation hearing, she was at a law conference in California where she said something that was 100% accurate. At the time, she was a Court of Appeals judge. And what she said was, of course, the identity, the values of the judge matters. A wise Latina woman would likely decide many cases differently than a white male. That's what she said. During her confirmation hearing, she couldn't deny saying it because it was on tape, but she completely walked it back and she completely said that's not what she meant. And that is what she meant. She got confirmed. And then a few years later, in a stinging dissent, basically said the same thing again.
Well, what does that have to do with?
Well, I'm saying what I'm saying is nominees to the Supreme Court
when you're doing your confirmation hearing. Yeah.
Yes, they lie. They lie all the time.
Jane Sullivan Roberts is John Roberts' wife. She's a lawyer. This is on theissues.org, ardently against abortion. A Roman Catholic like her husband, Jane Roberts has been deeply involved in the anti-abortion movement. She provides her name, money, and professional advice to a small Washington organization, Feminists for Life of America, that offers counseling and educational programs. And the group has filed legal briefs. Wow. So that's a really interesting point of fact that you bring up. What about Kavanaugh? How do we know how Kavanaugh or Alito? I think we know Clarence Thomas.
We know Alito because he dissented in the Texas case.
Oh.
Alito, Thomas.
But does anything change between his role or judgments on a lower court than on the Supreme Court?
No. Alito was on the Supreme Court in 2016 and dissented in the Texas case involving the same law. He wanted to uphold the Texas law.
Got it.
So it's easy. So it's easy for him, for Thomas, Roberts, and Alito. They've already voted to uphold this law.
You think that guarantees their vote? You have no question about that.
No, I never. At the Supreme Court, I almost never say guarantee.
What about Kavanaugh?
Kavanaugh is a 1990s type Republican. There's every reason to think he thought Roe versus Wade was wrongly decided. He's also a Catholic, I believe. But let me make the point I really want to make about all this. The conventional wisdom is the court is not just going to reverse Casey. It's going to weaken it, kind of like what it did with the Voting Rights Act. A few years before the Supreme Court struck down the Voting Rights Act, it issued a decision weakening the act and telegraphing what was going to happen in the future. And then, in fact, it struck down the law. I suspect we're going to see that here. However, I'm going to make a statement that's completely out of the blue, and then I'll explain it. It all comes down, I think, to whether Justice Roberts wants Donald Trump to be president. And I'm dead serious about this, and I can back this up. and I will back it up.
Go ahead. This should be good.
I believe there are 4 votes now to overturn Casey. Justice Roberts normally goes much slower than that. He'll do it, but it'll take him some time. 25% of the people in exit polls in the 2016 election said they voted based on the Supreme Court. And of that 25%, that's a huge number. Of that 25%, 56% voted for Trump. So that's a huge, doesn't sound that big, but it is when you think how close the election was otherwise.
Yeah.
So I'm hoping that if Donald Trump hates Trump, if John Roberts hates Trump and thinks he's terrible for America, and even though Roberts has been a Republican his whole life, thinks that this guy has to go, as many Republicans do feel, in their privacy, then he knows that overturning Roe and Casey would take a huge, huge issue that is favorable to Republicans out of the race.
So he votes.
So let me give an example.
Yeah.
Lynn's cousins, my wife's cousins, who are, kind of evangelicals in Michigan, they're basically a 1 or 2 issue voter. The number one thing is abortion. So if the Supreme Court overturns Roe and Casey and returns abortion to the states, that will appease them on that issue. They also care about guns, of course. However, I think they care much more about abortion. And once the Supreme Court gets out of the business of abortions, then the Republican Party will be hurt dramatically. There's no question about that. Fundraising wise and otherwise, the Republican Party benefits and has benefited immensely from Roe versus Wade.
So is what you're saying is that...
Wait, one more thing. No, let me finish.
Go ahead.
And the reason I say this about Justice Roberts is the only way to explain his vote in what is, to this day so far, the most important case he ever decided, Obamacare, is through the lens of an all things considered political decision. In other words, we all thought that Roberts was going to vote to strike it down, and of course he didn't.
Right.
And the conventional wisdom about that is to strike down Obama's signature legislation in June before the November election would have hurt the credibility of the institution of the Supreme Court. Whatever it is, had nothing to do with law. This case, as you already pointed out like 30 minutes ago, hope your audience is still with us. This case that the court has under the law is very, very easy. There is no medical benefit to this law. None.
Right.
0. And it hurts women a lot who seek abortion.
Well, they don't care about that, unfortunately.
Right. So here's what I'm telling liberals and progressives, and I am going to write this up after the case is argued. I think the best thing that could happen to America right now is for the Supreme Court to overturn Roe and Casey altogether. Just overturn it. Get rid of it. Be done with it. And I think if the Supreme Court, here's why I think that. As you know, I'm pro-choice all the way down. I think Roe is wrong, and Casey is wrong as a matter of constitutional law, but no more wrong than 100 other cases, like the voting rights case, like the Heller gun decision. They're all, on my view, they're all wrong. However, middle-class women in blue states will still get abortions even after Roe and Casey are overturned. Rich women in all states will still get safe abortions after Roe and Casey are overturned. Middle-class rural women who have a very hard time in red states, who have a very hard time getting abortions, and poor women in red states who have a very, very hard time getting abortions. Pete, that's true today. That's true today.
Right.
So for the pro-choice movement, how much do Roe, and it's going to be even more true when the court weakens Casey, which is absolutely going to happen. So I think for transparency purposes, for rule of law purposes, and for political purposes, we should hope that the court just overturns it altogether, returns the issue of abortion to the states and the people, which, by the way, is where it belongs.
Okay, well, but that would mean, just to be clear, that abortion will be safe, accessible, affordable, and legal in the states where the majority of the people believe that it should be, or blue states.
Yes. And it'll be illegal in red states. But as you pointed out like 10 minutes ago, it's already very difficult to get abortions in red states. In fact, Pete, the last time I researched this, so what I'm about to say now is 1 year old. It might have changed in the last year. But as of 1 year ago, there was not a single doctor living in Alabama who performed abortions. Because they couldn't, because they would be exposed and they'd be subject to danger, and their families would be at risk. There were 4 doctors who performed abortions in Alabama, but they all came from out of state. One came from Atlanta, one came from London, believe it or not. They flew in, would do abortions, and then fly out. I believe South Dakota has no clinics, or maybe one clinic. In red states, it is very hard now for poor women to get abortions. So it's not like Roe and Casey have done a great job in getting this right established. So there's a lot of advantages to liberals and progressives if the court was just to overturn it. And the problem is there are 5 Republicans on the Supreme Court who know that. Now, the people in your audience who are cynical are thinking, what is Segall talking about? Come on, it's a court. They decide cases under law. They don't care about the political stakes. Right. That's just wrong, and obviously so. So it's real. This case is not only here's the headline. The case on Wednesday is not only very important for abortion rights in this country, it is incredibly important to the 2020 election. Right.
That point is well made, and a really important and fascinating point to look at this decision, which will come around June in a nuanced way.
It'll probably come around June. It would not. It would not surprise me if this is another. So let me give you one example of what I'm about to say. It wouldn't surprise me if the court holds it over for a year. What do you mean hold it over for a year?
What do you mean hold it over for a year?
I'm going to explain. When Brown versus Board of Education, which was the case that said separate but equal is unconstitutional in 1954. In Brown versus Board of Education, it was actually argued the year before, and the justices didn't know what to do, and they were and so they held it over for a year. The Chief Justice then died. Earl Warren replaced him. Earl Warren was a master politician, and he eventually got a unanimous decision overturning separate but equal. My point, though, is they held it over for a year.
Why wouldn't they do that to create the situation that you're describing they would want in terms of the election, how it applies to the election?
So it would not surprise me at all if the Supreme Court issues an opinion in June which says we're going to hold this case over a year. We're going to hold this case for a year. Come back to us in the fall, and we're going to add a question to the case. What's that question? Should Planned Parenthood versus Casey be overturned?
Go right back.
I actually think that's the most likely result, because then Trump still has the Republican Party still has abortion as a positive issue for the election.
Which you cynically have always believed, and many others, I should say, is the real issue behind abortion. It's not nearly as much about reproductive rights or when life begins. It's just such an animating, motivating issue in politics to help people get elected.
Well, I think
so they can get all the other horrible things they want to get done.
I actually think you open the can of worms. I'll do it very quickly. First of all, there are millions of Americans who sincerely believe the fetus is a person and should be protected. I have no doubt about that.
Life begins with conception.
I am not ascribing bad faith to those people. But as far as the politicians go and the groups go, and where the money is, I think it's a number of different things. I think it's an anti-woman thing. I think it is a we want to pretend that we don't have sex outside of marriage thing. And I think it is a fundraising thing for the Republican Party. Yes, all 3 of those things.
Yeah.
But I want to be clear. I don't want to be misunderstood about this. There are millions and millions of Americans who in their hearts and souls believe abortion is wrong. And I get that. I do.
All right. What else?
I think that about covers what's going to happen on Wednesday. I do think what might be interesting is one thing that people should look for is A, does Justice Thomas ask a question? He's asked 2 questions in 10 years.
So weird.
I think he might, but we'll see. The other thing to watch for is this technical issue I was telling you about. Do doctors and clinics have standing to bring these kinds of cases? How many questions about that do the justices ask? Because they may, given the election of 3 months later, they might take that way out and dismiss the case on technical reasons, which would also protect the Republican Party, because then abortion's still an issue. That way, the Louisiana law is still in effect because the plaintiffs who challenged it don't have standing. The other states will then pass or reenact the same law, and it's still an election law issue. So for people listening to this who are going to pay attention to the arguments on Wednesday, pay attention to how focused the judges are on the standing question. Could be a big deal. And that's about all I have to say about it.
And we'll know that we'll have a lot of analysis in the afternoon after the case has been argued.
Post Wednesday. Yep.
Yeah.
Too bad we can't watch it, but that's the subject of a whole different podcast.
Yeah, because they don't have cameras in the courtroom, something you've also been railing against. Increasingly, many others have gotten on board that, and why shouldn't they? Including many lower court judges. All right, Pete, and one last thing, because I have a feeling you and I are going to be talking again, because although the abortion case is being argued Wednesday, there are so many other incredibly important cases this term. The Second Amendment is at issue this term. Trump's immigration policy is at issue this term. The Electoral College even is at issue this term, whether the whole faithless electorate issue. Can you change your vote from the time of the election to when your vote is actually counted? Immigration, guns, elections, and we should devote I would ask you to devote a whole podcast to a huge church-state case that is also in play. Yeah, I'll do whatever you say, boss. Yeah. Maybe we should bring some your friends that don't agree with you and to join us. Yes, that would be great. Yeah, I mean, religion, guns, abortion, immigration, elections. That's this term. Sounds like the name of my tour. Thanks, Pete. I appreciate it. Thank you, Eric Segall. Everybody, follow him right now at @eSpinSegall. Where is that blog posted again? It was posted Monday on Dorf on Law. Got it. All right. Okay. Thank you very much, and I will talk to you soon. My best to your family, pal. I appreciate it. And to yours, Pete, and hang in there on the other stuff. Yeah, we'll continue talking. Thank you. Okay, bye. All right, well, there you go. Eric Segall at @eSpinSegall on Twitter. Follow him there, and thank you very much for listening to today's podcast. Please consider a subscription on Patreon, where you can join with a paid subscription, which is the only way that this podcast can be sustained, because I do 3 episodes a week, and it's a lot of work, and that is the way to help support the work that I am doing. So check that out. Give us a rating wherever you're listening to the podcast. Hang in there, everybody. We will get through this. This too shall pass. Be the change you want to see in the meantime, and I will talk to you on the podcast Wednesday on Twitter @Pete Dominick, Instagram, Facebook, all of it. Look forward to hearing from you there.